Welcome everybody. I'm Elizabeth Beattie, Harrison Clark Rickaby's, head of the firm's in-house lawyer services. Thank you for joining us today on the session that's going to focus on data protection. With the law around data protection constantly evolving, staying up to date is essential to avoid risk and liability arising from non-compliance. So what we're going to look at today is how you can stay ahead of the data protection curve. Before we start, just a little bit of housekeeping. This is a Zoom webinar. It's being recorded and it's intended to be interactive. So there'll be a short presentation from my colleague and then it'll be over to you for your questions and comments. This session today is part of an ongoing series of added value sessions for in-house lawyers. They are designed to be relaxed and allow you to pick the brains of our experts. If you aren't comfortable asking questions on camera, you can ask a question via the typed chat facility at the bottom of your screen. What I shall do shortly is hand over to my colleague, Shriane, who's a legal director in our commercial team, who's an expert on all things data protection. Once Georgia's provided a presentation, we will then open up the panel to field your questions. So without further ado, Georgia, over to you.
Hello, and thank you for joining me at this lunchtime for our in-house seminar. As Beth has just said, it is all about data protection. And I have chosen this time subjects that are a little bit less bread and butter. They are not the usual why we need to have a privacy policy and all the terrible fines that might befall you. But these are areas of practice that have come to my attention recently. If you have any other questions, though, about more bread and butter topics, then please do ask. We're not limited to the subjects that I'm discussing today on my slides. I just wanted to expand the offering a little bit beyond what is very much a standard material. So I'm going to continue to talk today, not just about the Data Protection Act 2018, because that's the UK's national law, but also still refer to the European GDPR. And that's because, first of all, both of these laws remain very closely related at the moment, and rulings and practice in the EU relating to the EU GDPR have continued to have influence in the UK. And the other reason is that from my experience, many clients are actually operating across both territories. That we don't only work for UK clients, obviously, and many UK businesses are still operating in the European space as well, or maybe have partners and suppliers or even customers occasionally, so or other members of their corporate groups even. So on that basis, it's interesting to continue to reference both these territories, even though we like to, basically talk about the national laws now. Can we start with the next slide, please? So as you can see here, my focus is on the international transfers and the data privacy framework that's been put in place. So this is interesting because obviously we have been very preoccupied over recent years with how we can transfer personal data to the US. There have been the ins and outs and ups and downs of Schrems, and we have the European Union who have alternately given adequacy decisions or said, yes, this is okay, and then retracted them. So we've had a sort of a long and bumpy ride on this. At the moment, from a European perspective, if you transfer personal data out of Europe, you are free to do so to countries where there is an adequacy decision in place. And there are about 15 of those, I think, at the moment, maybe a couple more. Some of them are a little bit unexpected, and they're not necessarily the big commonplace ones. The US typically was not on that list. In July 2023, the European Commission did give an adequacy decision for the US on the basis of the introduction of their data privacy framework. And the UK then added themselves to that same framework, and it was called the Data Bridge for the UK, on the 12th of October last year. So this is all still relatively new. Personally, we come across relatively few US companies who are actually part of the data privacy framework. So I'll give you a little bit of a rundown about it, but it is not the only way now to transfer personal data to the US. So we start with the Data Privacy Framework, which is a program that's administered by the International Trade Administration and the US Department of Commerce. It works by US entities, organizations of all kinds, not all of whom are able, you need to bear in mind, not everybody's eligible, but many are, and they will self-certify their compliance with the data privacy framework. And then they get added to a list, which is published on the department's DPF program website. So there is an official list of participants. Once they have self-certified, what's to say they comply? Well, as soon as you self-certify, you commit to it, and then it becomes compulsory that you are compliant, and that compliance is then enforceable under US law. There are spot checks done, and you are supposed to sort of re-engage annually. So you have to, if you're a US company, you have to re-register every year, and there are sizable, fees involved in that, to be honest, depending on the entity that's involved. What's the point of the DPF? Why has that suddenly changed the landscape for transfers? Why did the European Union suddenly say, okay, we'll give you adequacy? It's because the data privacy framework introduced some of the elements that were previously missing and challenged by Schrems in the Privacy Shield setups that we did have. So what the DPF has introduced is an independent judiciary enabling independent review of data protection. So it's taken it out of the realms of the usual courts that maybe aren't experienced in this field. And they've been quite careful, apparently, to recruit a judiciary who have experience in data protection. They've introduced a new court system for these appeals. And they've also taken steps to limit the right to access personal data by local governments and government bodies, which previously had absolute primacy. And now there is still priority for them, and they are still entitled to, but in a much more limited way. They have to prove there is a national interest point, and not just simply say, well, we're the government, we can do this. It is a little bit more complex than that, but those are the broad sort of bases of the change, because those were the elements that were very much missing in the previous Privacy Shield options. So the ICO, the UK supervisory body, and the European supervisory bodies have remained quite guarded about the extent to which the DPF actually is totally compliant with European and UK data protection law. They say there are some real loopholes remaining, and there's been a review. Particularly risky at the moment is the special category data transfer. So if you work for a business that transfers special category data to the US, there is a need to be very specific with the US recipient that they will be receiving this special category sensitive data and need to up the security standards on it. At the moment, there is no recognition under the DPF of special category data. They just have an obligation on the US entities to comply with and provide higher protection when the transferring body, i.e. you, the UK or the European body, sends that data. So it's up to the European body or the UK body to identify which data needs that special treatment. There's obviously a risk there. If that's not done, then what happens is special category data, apparently deserving of more protection, gets sent without that protection. Just as a reminder, special category data, it's not financial data. It's not the things where we think, oh, we could have fraud. It is the data that is of such a personal nature that in many areas of life, people might face prejudice or disadvantage, as a result of it becoming public if they don't want it to. So it might go to race, religion, sexuality, trade union membership. Those are all typically the areas where people have been disadvantaged. There is also no protection written into this DPF for artificial intelligence decision making, which is a requirement under the European law. So if decisions are made on the basis of artificial intelligence, then under European law and personal data law, we're allowed to challenge that and require human decision making. Now, that is not incorporated in the DPF. And the other thing that's not incorporated in the DPF is that there is no right to be forgotten. So you cannot request deletion. And there is no right to withdraw consent. So if you've consented to the transfer, you can no longer retract that consent and have your data either returned or deleted. So those are still the three slightly dodgy bits about the DPF. That means that actually, given the cost of registering and this slightly dodgy part of it, that many US entities have decided not to register. And therefore, the transfers to the US remain basically based on the standard contractual clauses and the IDTA, the International Data Transfer Agreement or Addendum that the UK has developed. In both cases, supported them by a transfer risk assessment. And why we have maintained those is because as the DPF has introduced all the safeguards as through the judiciary and the courts, we can rely on that using the SCCs and the IDTA as well. So rather than go the data protection framework route, we can still use the contractual safeguards, or use them again, perhaps is a more accurate way of describing that. Can I have the next slide, please? So this is just to look at transfer risk assessment. So under Article 46 of the GDPR and Recital 108, just for reference, there is a requirement that there be a risk assessment undertaken when there is a transfer out of the EU or the UK. So this is usually a risk assessment that is conducted by both the party transferring the personal data and the recipient of the personal data. So that would be the UK company or the European company, and say they're transferring to India, the Indian counterpart. Both parties should be involved in this transfer risk assessment. The ICO has put a tool on their website, which is very lengthy, and they've also provided a very lengthy guidance document. And if people are feeling very bold, that's a useful tool to use, but it is complex and it's quite a lengthy tool. You are not bound to use that as a tool for the transfer risk assessment. They may take any format as long as it details an actual risk assessment. Now, what is required? So the ICO and the EU have taken slightly different approaches on transfer risk assessments. If you're using European, or if you're actually going the European personal data route and transferring European personal data, they insist on an evaluation of the risk every time to take account of the changing landscapes. The ICO has taken a much softer approach. Excuse me. The ICO has decided that the risk needs to be assessed firstly as to what is the nature of the data being transferred. Is it high risk data, or is it simply somebody's email? Where it's simply somebody's email, that's no longer considered that much of a concern. And where the US is concerned, the ICO has certainly said that you can take the DCIT risk assessments into account, and that would then be absolutely fine to base your transfer on. The risk assessment is generally low risk unless you have very personal, sensitive, special category data. The point of the ICO approach is really to simplify the risk assessment and to look first, as I said, at the nature of the personal data being transferred, and then look at where is it going? Can the data subject's rights be enforced? And is there a regime in place that is respectful of those rights and has a judiciary that will enforce those rights and is free to enforce those rights? So given the introduction of the DPF, we know that judiciary is in place in the US now. So we're pretty comfortable with US transfers of personal data, which is refreshing. Where you have data that is higher risk or sensitive, then obviously a fuller risk assessment would be required. And as I've just said, you should flag to the recipient that you're sending them that sensitive data in the US. We're not only talking about the US, though, and there are many, many other third territories we transfer to that are not on the European adequacy list and where we have to do a transfer risk assessment. Can we go to the next slide, please? So the GDPR and the Data Protection Act remain the gold standard. And nonetheless, there is really developing regimes all over the world. As we know in the US, for example, we have individual states who are passing their own laws. Then they have the Health Insurance Portability and Accountability Act, the HIPAA Act, which applies to medical and health data. So in the US, there are many sources of privacy law. In some of the other territories that I deal with, there has been a lot of development of own regimes that are more or less in line with the GDPR and often geared towards trying to achieve adequacy from the European Union and the UK in order to just have easy transfers of personal data. For reference and a reminder, those regimes don't need to be the same as the GDPR, but they do need to provide a similar or equivalent protection so that European and UK citizens sending data abroad have that same protection. That's the aim of the game. I've personally obviously conducted a number of reviews of different countries for the purposes of these transfer risk assessments. And I think it's worth noting that Australia, Brazil, Canada, Israel, Egypt, some of the Gulf states, they have really ramped up data protection laws recently. In some cases, those bills and those laws are not yet fully enforced, or they have just come into force. And the most common problem is then that they haven't really got the enforcement bodies in force yet. So they might not have courts that are specialist in data protection. They might not yet have a supervisory body open. And that obviously means that it's difficult still to rely on enforcement. They might have laws in place, but what happens if you break them? Also, the financial fines generally are much smaller. So the pressure on companies to comply is much less. That obviously means they are not quite as reliable, and that's why we do these transfer risk assessments. It does take into account, when you do your transfer risk assessment, the entire landscape. And of course, there we have other points to look at. And that is, for example, that in some cases, those local laws might be stricter. So, for example, the Gulf states and China, for example, have very, very strict rules on exporting their own national personal data. So that's an area to watch if you're in business with partners there. Because while you might be able to, with a transfer risk assessment, send data there, it might be difficult for them to send data back. Local advice obviously should be sought on that if you're really going to be exporting significant personal data from those territories. More problematic, though, from our point of view, is if there is a third territory's government that has priority rights and access to personal data. So, for example, this was the US in the past. Now it is definitely China, for example. They have a very strict rule in favor of the government being able to access personal data that is in any commercial use. So they can require companies to just send them their databases. So if you're doing business with a Chinese company, you're not, whatever the agreement's going to say, that company does not need to and can't necessarily keep that personal data from being transferred to the government. The European Data Protection Board has undertaken some research and reviews of these territories and has specifically said that, for example, China is not the safest recipient country for European and UK data. Something to bear in mind. We also have other territories that we know there is a real risk, and I've called them the bandit territories because there is a lot of hacker activity there. And it won't surprise you that at the moment, the obvious examples for this are the Ukraine and Russia. Ever since that conflict has come to light, there have been a lot of hacker incidences, and they have also been identified as not in quotes, safe territories to send European or UK data to. Naturally, while they're in the state they're in with war going on, there's a very slim chance as well of being able to enforce any rights there. So it does fly in the face of all the guidance. Next slide, please. So now we're moving on to a different focus. That was all about the international transfers and risk assessments. We're now going to have a little look at the focus on data subject access requests. Now, when I decide on these topics, I try to take it from my daily experience and the questions I'm asked. And we've recently had a number of clients who have asked about guidance for data subject access requests. So I thought this might be useful. The European Data Protection Board also recently conducted a review of or developing practice and process on data subject access requests and has issued new guidelines, but really those guidelines reinforce the letter of the law. So it's not new, it's just a reinforcement of, yes, actually we do mean this and you do need to do this. So I'm going to run through that now with you. First of all, you get a personal data access request. It must relate to a living individual, not to a company, and not to confidential records or any other form of information. So if it isn't actually somebody's personal data that's being requested, then it's not a personal data access request. You need to make sure you've identified that individual properly. Sometimes people think, well, it's the same email account, but I would stress that really the liability is on the controller. If you hold that personal data, you need to be satisfied that you have identified the right data subject before you give them their data. It could be somebody's hacked into their account. It could be a friend who's found the account left open, and or not so much a friend, and is having a look at data. It's really a tricky issue, and you must get ID. If it's not actually the person making the request on their own behalf, then you need to see authority. So if you are contacted by lawyers making a request on behalf of somebody, they should be sending you at least passport, ID, or proof of address. So then once you've identified your data subject, you have 1 month to fully, well, not even to fully reply, to reply. And you must acknowledge that data subject access request as soon as possible. And you must confirm that you're looking at it. Usually one would expect that 1 month is enough to provide the reply. If it turns out that actually you need more time, you can extend that time. So, it's not sleepless nights for a month. You do have a bit more leeway. You then need to get to looking at the records. So you're searching the records, and yes, that is problematic. It can be problematic. What you want to do is narrow down your parameters for your search as much as possible. So you really should ask them to give you an idea of what they're targeting, or a time frame perhaps. And you should note that if this request remains unnecessarily broad, for the last 10 years, and there is no particular focus, so they're not just asking, say, for their HR records or for this one purchase record that they've bought something from you with, then the question is, what are they really wanting to do? Are they really wanting to see every last bit of personal data you hold on them? Or is there some other malicious intent and no intention really of seeing the personal data, just the intention of putting you through hell? You really normally would expect somebody to be able to give you parameters that are more sensible. You also need to make sure that you are actually the controller of those records, because in many cases, for example, recently I've got clients who are processors of large volumes of data. They've been asked to provide that data. And as we were considering their data subject access request, it became clear they weren't the controller. They were processing it. So they then need to direct that request to the controller, and they can't just release that information. So one of the checks you should run is, in what capacity are we holding this personal data? So then you conduct your search, you see all your records, and you have, strictly speaking, 1 month, and normally up to 3 months if it is a very complex search and if you haven't been able to sort of set more narrow parameters. When you provide the documents, what do you need to do? So you need to protect, first of all, third-party personal data. You are releasing only the personal data relating to that data subject, not everybody. That doesn't mean that you don't release data or the documents that are in question, but you can heavily redact in order to protect other people. You must, otherwise you're just creating further breaches by revealing third-party data to the wrong party. You also do not need to damage other third-party rights. For example, you have a confidentiality obligation to another business, or it's your own sensitive business information, including plans or IP rights. You do not need to provide that kind of information. It is not a data subject access request is not a permission to access other confidential information. It is really only there to access your own personal data. Recently, I've given you the name of an Austrian case. Recently, they reviewed as well, what does, providing a copy of personal data mean? And the court held that it isn't just a summary of personal data in a table. It may include copies of documents for context. So it may be that the full documents or even extracts of the documents have to be provided. They said it was a faithful and intelligible reproduction of the personal data. So it could be that in some cases where there's a tetchy document that's very confidential, you summarize the personal data for that party out of it. And you can say why you're only providing a summary. It's perfectly legitimate to say it is a confidential document, confidential business information or third-party information in it. And then you would enable them to understand the context if you wanted to provide them with the document heavily redacted, if that's possible, to protect other parties. And you really want to give them the understanding of why you have that personal data, what's the purpose that you hold it for, and that you provide it for them in an accurate way. And the reason for that is that data subject access requests are still seen as a bit of a gateway right. So if you are a data subject and you want to know, do they hold accurate data on me? Why do they hold it? What are they doing with it? First of all, you might say, I want a data subject access request raised so that I can see what you've got. And then I can check whether it's good, accurate, whether you're holding too much. And that's an important right. So that's how the information needs to be provided. As a controller, you must always balance the rights of third parties, and you must always remember that your primary right is to hold personal data securely. So while you reveal some to some parties, you cannot reveal other parties' personal data, and it's really important to fall on the right side of that. To remember is that legal privilege applies. So if you are taking advice, that is all protected. You don't need to blank out names in documents. And also data subject access requests are not a means of sort of jumping to the discovery phase of litigation. That's absolutely prohibited and is a good reason for refusing a subject access request. Move to the next slide, please. And on to the next topic as well. This is really to quick look at something that has come up recently for me quite a lot as well, is the wording of clauses that we put into data processing agreements. And two particular themes have come up. One has been the right of the controller to conduct data audits when they have appointed a processor. And the other one that comes up quite frequently is indemnities. So just talking about the data audit first of all, to remember the ICO also has a right to audit all controllers under section 146 of the Data Protection Act. And so under that then, if you look at the link, the way that links down, we have the ICO checking the data controllers, and then of course the data controllers have a duty to check the data processors. So it's not just a right to audit, it is also an obligation on the controllers to audit under Article 28 of the GDPR, because controllers shouldn't use processors who aren't compliant, and they need to demonstrate that compliance. They also need to appoint these processors with a written agreement and make sure that those processes are then complying with the clauses in that written agreement. So that's where this right to audit comes from. Practically, of course, it is pretty hard to imagine that every controller might go and audit. If you think about, say, Amazon Web Services, they can't have everybody who's storing data with them conduct their own audit. So what the reality is that actually self-auditing is the most common way to go. And that is how I, rely on the clause in the data processing agreements. I usually add a self-audit clause in there, an annual one, no more than once annually for sure. And if you're not a big processor, then probably less than that. Conducting that audit using a good third-party auditor on your own behalf, and then providing those reports to controllers would normally be satisfactory. And it's very rare that anybody would ask them to also come in personally and audit. But you should bear in mind that any controller does have the right to actually conduct that audit themselves, or have their auditors conduct it on their behalf. Can't be denied. So it is a possibility that you will need to allow people to come in and audit, but it's not a very practical solution. It's expensive, it's awkward, and most of all, it tends to lead to more breaches, I think, than anything else, because if you've got a number of audits being conducted throughout the year, then you've got people trawling through your systems. So if you can avoid it, put the self-audit clauses in, is the summary on that one. And then indemnities. So the issue comes up regularly. People are very worried about liability under data protection. And we are very used to giving indemnities, say, in a business sale, where we might say that we're indemnifying against data protection breaches that have occurred in the past. We tend to try and avoid them in a data processing agreement. It sounds fine that they might want to put in reciprocal indemnities, that they'll indemnify each other for whatever they do wrong. But I'm sure that it's a very reliable route to take, and I'm definitely not a big fan of them. Why? Because each party already has that direct liability to the data subject in any case, which they can't escape in law. And so to then start to try and reallocate it between them sounds like a nice idea, but actually probably won't work. And it's not reliable because, generally speaking, where you have an indemnity that relates to a regulatory compliance point, that's usually seen as strict liability. So say the controller wants to have an indemnity from the processor for any bad processing that occurs, and have any fines that they might incur reimbursed by the processor. The issue here is that where it's a regulatory fine, you would have strict liability, and therefore the processor could simply say, this is illegal, this is a regulatory fine, you can't enforce this indemnity against me anyway, because that avoids the public policy of strict liability and fines. So it's on wobbly ground. If either party were to challenge that indemnity, you would have to prove absolute innocence and that you have been totally compliant yourself and not skipped a step. Now, what would those steps be? Usually, both parties would need to conduct due diligence and ensure that the other party is willing to comply, rather than just put an indemnity in there just in case. Because the minute you're putting an indemnity in there just in case, you're probably doing it to cover some risk that you are worried about or suspect might occur. The other thing worth bearing in mind is that the ICO, when they hand out fines, they do a long inquiry into how the breach might have occurred, for example, or where the non-compliance has occurred. And if they find the non-compliance or the breach and they allocate a fine, they usually do it in accordance with wrongdoing. So they will hit the guiltier party harder, if you like, with the fine, and therefore then reallocating this using an indemnity is again against public policy and might well not stand up so well if questioned by the indemnifying party. The better way to go is definitely to take the compliant action and maybe do the due diligence and put the clauses in place and make sure that you're both compliant, and then just accept the fact that as data is generally risky business, each party has to comply and carry their own risk. And if they don't, then it's quite likely the ICO will be able to identify which of them didn't. And that only because people traditionally think we'll put the indemnity and we'll be fine. And I don't think that that is the way to go. Next slide, please. So my final little topic today is the progress on the UK Data Protection Bill. So the Data Protection and Digital Information Bill was first, in a previous version, put before Parliament in 2022. It was proposing quite a lot of divergence from the European GDPR, and there was a lot of concern that it would undermine the adequacy decision. So it has been reviewed, and we now have version 2. Even version 2 significantly loosens some of the controls on data protection. But it has received, it has been put in before the Houses of Parliament, and it was due to receive royal assent on the 10th of June. But when Parliament was dissolved on the 30th of May, it too got a bit lost. And so at the moment, it's uncertain where we're at with Bill number 2. The same risks still apply. It does loosen the obligations, and there is a possibility that it might lead to the adequacy decision being revoked. The point is that where it loosens the rules a little bit too much, then the data protection compliance with European GDPR is not adequate and not enough to protect citizens' rights. So we need to consider what they're doing. There is a question of no longer requiring a record of processing activities unless you are a high-risk business. High risk can mean either particular high types of data, or it can mean high volumes of data. It's taking away the consent requirement for direct marketing, so that it now can be undertaken on legitimate interests. It's allowing a refusal of a data subject access request where those are made not in good faith or where an abusive process is suspected. It proposes doing away with the requirement of a data protection officer. And those, obviously that is a nice reducing of the burden, but it would only apply if you are a UK business only dealing in the UK with UK data subjects, because the European data subjects still have the EU GDPR to rely on. And therefore those standards that we're used to will have to be maintained for any larger client or business who does business with the European Union. It's unlikely that you're going to have two separate levels of compliance, one for the national and one for the international. So while it reduces the burden on small national businesses, it won't reduce the burden realistically for larger businesses. We can move on to the final part of the talk. I've come to the end of my presentation. Thank you for listening. And if there are any questions, I'd be delighted to have them.
Thank you, Georgia. It's been a really interesting summary of the current position. I have got a handful of questions for you before you can go. I'm conscious you've done a lot of talking, but if you can just bear with us. One question's coming in relation to China. We have suppliers in China, we've got contracts with, obviously. How much of a problem is this if we transfer our staff personal data to them?
So China is a tricky area, and even having Chinese parent companies. So sometimes we're doing business in the UK and there's a Chinese parent behind it. All of, the European Data Protection Board have been quite damning about it. All transfers of personal data to China are at risk. And so staff transfers and personal data related to staff and employees is a risk. The problem with staff and employees is that they can never really consent or refuse. So it is difficult. There is no easy, safe way through that. If it is just low risk personal data, like emails, that's less risky. If it is more important personal data, such as salary information for payments, then there are concerns. The best thing one can do is actually ask the staff or inform the staff, but even that won't get you off the hook if something goes wrong. So it's a risk area. I think everybody needs to be aware.
Thank you. Picking up on the indemnity issues that you've mentioned, and liability in the DPA, what are your tips for managing liability for data processing?
So a data processing agreement is usually put in place because there is a bigger services agreement already in place, or a framework agreement. And so you would normally have the limitation of liability in those main master agreements, if you like. Depending on which side you're on, whether you're the processor or the controller, the options are there to include or exclude liability for data losses, including personal data losses. One option would be to manage all of that in the main agreement. The other option would be to carve it out of the main agreement and just provide for it in the data processing agreement itself, and either limit your liability to a very small amount if you can get away with it. It's tricky, but sometimes you're lucky. Or oblige your processor to really cover themselves. So there are options between the framework agreement and the data processing agreement. You can distribute your liability across the two. So that's sometimes an issue worth considering.
Thank you. Just a couple more. I think we've still got time. It's that thorny issue, Georgia, about what we think it might be a malicious data subject access request. And the question is, can we reject or refuse request if we think that it is a malicious one, or it's just an unhappy customer using it to get some money from us? What are your thoughts?
Yeah, it's difficult because it is, unless there are repeat requests made at the moment, an excessive request would be, a repeated request. Manifestly unfounded request is very difficult to prove at the moment, but this is where the revision by the new data protection bill is interesting, because they are taking that into account. They are saying where there's an abusive process, or they don't believe it's a data subject access request made in good faith, you could refuse it. Currently, you can't really refuse them. Currently, the view is that the data subject has an overriding right. They can't be charged. At very most, if it's a very lengthy and awful request, you could maybe raise a charge, but you can't really refuse them. So it's very, very difficult to refuse a data subject access request at the moment. The best route to take is to try and narrow the parameters as much as possible and identify. And if the data subject is not keen to narrow those parameters, then that is almost the closest you're going to get to being able to show that it's an unfounded request.
What about the position where you've complied with the request and they just come back saying we're not satisfied, keep asking more questions, or they are say you've got more documents, they're on a real fishing expedition? What can you do in that situation? Because that's quite common too, isn't it?
Yeah, I mean, there are ways of, you're not bound to keep searching. There are ways of justifying the results that they've got, and explaining why. What we often get is people making data subject access requests, and they've got a certain document in mind that they think exists and that they need to see. And sometimes that is not disclosable. And so you can just knock that back by justifying why it hasn't been included, or why there is no more for them to see. Also, we're not obliged to keep every piece of paper and every piece of data forever. So if the policies are that actually we delete our data after 3 months, I'm sorry, we haven't got it, then that's also okay. But that would need to be in the privacy policy. So there are things you can do to reduce the liability to this kind of thing. And complaints, ultimately, the data subject can complain to the ICO. But if you can show that you've conducted the search in the proper way, and there are good reasons justifying the results that you've got, you are usually okay. Providing you respond. The worst thing you can do is not respond.
Right. So long as you show you've been reasonable and dealt with it properly, then that should, if they do go to the ICO, then you should be, you know, sort of in a sort of safe position.
Yeah, that process should be followed, but then you're okay, really.
Okay, that's great, thank you. A final question here. It's not something I don't think we've actually covered it today, but the question is, we've recently had a minor data breach that was an internal data breach. They thought that they had to report all data breaches, but has the practice changed at all on that?
Yes, absolutely, it has actually. Right at the start, we believed that everything would have to be reported constantly. And everybody was concerned that they had to ring the ICO the minute somebody missent an email. And for a while that happened. But actually we've all had different guidance actually from the ICO in the recent years, saying that if it is not something that actually carries real risk of harm and loss to the data subject, then you keep an internal record, you record all the things you've done wrong and what you should do right next time. But it stays an internal record only, and you don't need to report it. So it's only the most serious breaches that need to be reported to the ICO these days.
Great, thank you very much. Well, we've gone through all of the questions. Thank you very much, Georgia, for your time today and for explaining everything so clearly, especially for those of us, I talk about myself in that one, who's not as familiar with this area as perhaps I should be. It's been really useful. Thank you. To everyone who's joined us for this session today, thank you for joining us. Georgia and I hope you found it useful. If you have any queries that arise as a result of this session, Georgia's details will be provided, you'll be sent her contact details so that you can pick up with her privately if you have any queries, or else if you ever want to brainstorm a particular issue, she'd be very happy to talk to you. In the meantime, again, thank you for joining us, and we look forward to seeing you for our July session. Bye for now.